Well, I thank you for coming this afternoon, and that is a good setup piece for some of the things I'm going to get into in just a moment. But I want to thank everybody here for their most gracious hospitality. Rich, thank you for your for planning this and for interfacing with me over the last half a year or more as we planned this, and for all of your help in getting me from the airport and back and setting me up. Dean, it's a pleasure to be here. Dan, I thank you for your wonderful gifts, and Dan also took me to Gold's Gym this morning and made sure that I didn't collapse because of the altitude, and got me back after my workout. So I thank you all, and I don't mean to leave anybody out for your hospitality. It truly is an honor to be here. It is fun to get out and do these speeches as I'm able to across the country, and I'm heartened that now, several years after the Kitzmiller case, that folks are still interested in this very important topic. I was a player in a drama that has extended out over generations in the United States and indeed in parts of the world as well, and we'll get into that as well in just a bit. There are, of course, humorous aspects to this. That dour person that you saw that they elected to have play me in Judgment Day does not adequately reflect, I don't think, my true demeanor, but I guess when you want to judge, you get into central casting and you look for somebody who's vaguely mean-looking and looks dyspeptic. But I do enjoy things that are amusing, and I take that sense of humor with me in all that I do. I spoke last fall at a number of places, and this is sort of the start of a number of speeches I'm going to give in 2010. But one of the places I went to was Rutgers University, which, as many of you know, or most of you know, is in northern New Jersey. And I looked for I was thinking about a local hook, because I was in New Jersey, and what it brought to mind was the Bard of New Jersey, their famous native son, Bruce Springsteen. And it's interesting because most people don't know that Bruce Springsteen had an interest in my case, and he has eclectic tastes, and was interested in what was going on over in Pennsylvania while the trial was playing out. So in the midst of the trial, I recounted the story at Rutgers, it's a true story, he was playing at Giant Stadium in northern New Jersey, and he introduced a song that he doesn't play very often, and the song, appropriately enough, is part man, part monkey. As he was introducing the song, he said to the packed house at Giant Stadium, he said, he said, there's a trial going on over in Pennsylvania. It seems like in parts of Pennsylvania they're not sure about evolution, but he said, boy, he said, here in New Jersey we're counting on it. So even Bruce Springsteen was interested in it in the time of the case. Late last year, as again many of you know, we passed the 150th anniversary of the publication of Charles Darwin's Origin of the Species, and it also passed last year the milestone that was the 200th anniversary of Charles Darwin's birth. And 4 years ago, over 4 years ago now, of course, I was in the middle of the maelstrom that you saw represented there, and I really do commend that to you. If you have an interest in the topic beyond anything that I say here, I would commend Judgment Day to you. You can download it from the NOVA site. I think you still can, and if you can't, you can obtain it pretty cheaply, I think, on Amazon. But it was a marvelous production. I was happy to help the producers from NOVA, and I'm sure some of you watch NOVA regularly. I'm awed by their talent, and the retelling of the story was entirely accurate and balanced, and it is something that you may find interesting if you've not had a chance to see it. But I wondered last year as I went about speaking at different places in that sort of Darwin year, if we brought old Charles back now, if we had the ability to do that years and years after his death and on the 200th anniversary of his birthday, would he be surprised that we're having such a controversy still in the United States? And I think the easy answer that he probably would not be, excuse me, surprised, because he knew how controversial his findings were. And if you've studied Charles Darwin, you will know that he was not necessarily happy with where the evidence was taking him at various times, and did not release what became Origin for a considerable period because of his fear. And it was a justifiable fear of the backlash that he would receive. And I want to talk today, in the time that we have, and of course take some questions as well, about how we arrived at the point of Kitzmiller versus Dover, my case, talk a little bit about the case, and perhaps where we go from there. Now, again, students of American history, generally, students of the law, students that are interested in the issue of the evolution wars in the United States, you all know about the Scopes case, and that's sort of the granddaddy of my case, or great-granddaddy, and that took place, as you well know, in Dayton, Tennessee, in the mid-1920s. The law in that case, and I think people know about Scopes, but if you haven't had occasion to revisit it or look at it, it's a very interesting interlude. It was a very brief law at that time in Tennessee, and it said teachers in public schools are forbidden to teach any theory that denies the story of the divine creation of man as taught in the Bible, and to teach that man has descended from a lower order of animals. It's pretty simple. And the law sat on the books, and people didn't violate it, and it wasn't talked about very much. It was a fairly recent law. But the ACLU and others decided that they wanted to take a run at this, and they found one John Scopes, who was a young biology teacher. They importuned him, and they said, we're going to have you violate this law and run it up as a test case. And he was a willing party to it, and he did. And of course, then came the Scopes trial, which was this collision that, in a sense, my case was related to. They called my case variously the second coming of Scopes, or Scopes 2. But in Scopes, it was a criminal trial, and it was a show trial. Everybody knew that John Scopes was going to be convicted. This was something that was to prove a point. They thought perhaps they'd have something that they could do on appeal. But the jury deliberated for 9 minutes. It found Scopes guilty of violating the law, and the judge fined him $100. It pitted two giants in their time against each other. And those giants, of course, were William Jennings Bryan and Clarence Darrow. They were formidable intellects and attorneys, and they really represented the two sides of the debate. And Scopes, in effect, I think, in its aftermath, showed kind of the two dogmas that existed and the shifting sands in America at that time. You had a sort of 19th century Victorian propriety that faced off against the progressive and emerging scientific thought rapidly taking hold then as they moved into the third decade of the new century. Now, while Scopes was taking place, there was the beginning of what became a law in nearby Arkansas. And that state, just 3 years after Scopes ended, approved a referendum that prohibited both public schools and universities from teaching evolution. And believe it or not, It's hard to believe as you look at this through the prism of the distance that we have today in 2010. But the law that was passed in Arkansas that was even broader than the Tennessee law stayed on the books into the 1960s. And there was a collision again in the 1960s, but this was the real deal. And it was not a show trial the way that Scopes was. And that case was Epperson versus Arkansas. Again, what happened was that forces who wanted to challenge that law found a very willing individual, a young biology teacher who I've had the privilege to meet. She's still at it, by the way, still teaching, Susan Epperson, marvelous person. And she said, all right, I'll go out and violate the law, and you can make me the plaintiff in the case. So this was a direct challenge to the law by Susan Epperson with abundant help from a variety of groups who felt that it was time to get these laws off the books. The case went all the way to the United States Supreme Court, and the Supreme Court, in fact, struck down the Arkansas law. This begs the question, though, because Epperson happened until it was decided by the Supreme Court in the latter part of the 1960s. What was going on between 1925 and the late 1960s? And for that intervening period, evolution in many places in the United States simply was not taught. And I think if you question your living relatives, particularly grandparents, great-grandparents, depending on your age, your parents, you'll find that for great periods of time, in the middle of the last century and up to the 50s and 60s, many school districts across the United States simply didn't touch evolution with a 10-foot pole. Well, what happened to trigger the teaching of evolution? Most believe, and I think this is generally true, that one of the triggers that caused evolution to be brought back to the fore and precipitated some of these cases was an event that happened in 1957. The Soviet Union launched a steel orb into space. You know your history again, that was known as Sputnik. And it panicked the United States, and we had what became known as the space race. And we had thought leaders and politicians, typically reactive, I think, who felt that not only were we behind in the space race, but we were behind in the science education area, and so people amped up their curricula to put things in that hadn't been taught for years and years, at least in many places, as I said, in the United States. But at the same time that this was going on, interestingly enough, there's something else tracking that I think ultimately led to Epperson and later my case. And that was a sea change in the Supreme Court of the United States. And that began its process over 60 years ago in a case known as Everson versus Board of Education. I won't bore you with the details, that's not my purpose here today. But it was the case was a sea change in this respect. It signaled that there was an emerging consensus in the Supreme Court that the Establishment Clause, in fact, had part and parcel within it, the Establishment Clause, which holds that Congress shall make no law respecting an established religion, that not only was it applicable to the states, but also that within it you had the concept, quoting Thomas Jefferson from long ago, of a wall of separation between church and state. Prior to Everson, the Supreme Court didn't get involved in these disputes. You didn't have issues about school prayer. You didn't have issues about teaching creationism in schools or banning the teaching of evolution, as it were. But the Supreme Court essentially signaled some now 63 years ago, that it was going to countenance these suits, and it was going to scrutinize things that took place, particularly in public schools, that it believed violated what it held was a clear interpretation of the Establishment Clause, finding that wall of separation between church and state. And Epperson, in fact, allowed the Supreme Court to do what it did in Epperson when it struck down the Arkansas law that banned the teaching of evolution in both public schools and universities. And think about that. Think about that. That law stayed on the books. You couldn't, in a university in Arkansas, invoke evolution at that time, lest you run afoul of the law. Now, it wasn't, to be sure, enforced, but it could have been enforced, and it stayed, as I said, and remained good law for half a century at least. So after Epperson, there was sort of a retrenchment, because the creationist forces in the United States, and they're very strong, and understand, as I give this narrative and this history, my purpose is not to denigrate anybody for what their thoughts may be. This is indeed a free country, and you can believe what you choose to believe. However, we do have, as I frequently say, this troublesome thing to some people that is the U.S. Constitution, which means that what you can do with your beliefs is sometimes limited. So the creationist community decided, well, we've got to take a different tack. What did they do? Well, they retrenched, and they passed what, in many states, what were known as balanced treatment laws. These balanced treatment laws mandated that if you wanted to teach evolution, if you elected to teach evolution, although you didn't have to, you had to give equal time to creation science. A series of cases then followed, flowing from that sort of new tack that was taken by the creationists. Edwards versus Aguillard in 1987, which struck down a balanced treatment law in Louisiana. And in that case, which really was a particularly instructive to me, in my case, it found that creation science, which is what it was called, was not science at all, but merely a reconstituted version of creationism. In other words, to call something, to simply put science on the end of it doesn't make it science. The judge in that case, a judge by the name of Overton, a very, very good and very thorough member of the bench, decided, as I did in my case, that he wanted to drill into what this thing called creation science was. And he found that it was just relabeled, as I said, creationism. So that set the stage, really, for what happened afterwards, and that was the Kitzmiller case that landed on my docket approximately, about 17 or 18 years after that case was decided. And why did Kitzmiller happen? Well, first of all, there was another retrenchment after the jurisprudence, the cases that struck down creation science, the balanced treatment statutes. And what was that? Well, you had the development of this concept known as intelligent design. I've joked with people about intelligent design that, you know, anything, any phrase, whoever dreamt it up, you know, if you have a phrase that has intelligent in it, I guess it must be good, you know. And I think perhaps that was part of the thinking as they decided to label this concept. But it really is a relabeling of something that is quite old and has been around and has origins that go back centuries, not just decades. But the label was new. And as you heard in the brief DVD snippet that you saw, it posits essentially intelligent design that certain life forms are so complex that they could not have randomly occurred or evolved, for that matter. and that they must be the product of a designer. And while intelligent design accepts that there is some evolution within species, it rejects Darwin's view of speciation. It certainly rejects then how new species arise. So it cuts out, it really cuts the heart out of Darwin's theory and indeed evolution as it is taught today and as it is known by the scientific community. So the executive summary of my case is simply this. The school board in South Central Pennsylvania enacted a policy that mandated that at the commencement of that portion of the 9th grade biology curriculum that included evolution, teachers would stand in front of their classes and they would read a statement. Paraphrasing the statement, it was that intelligent design is an alternative to, the alternative to evolution, that it is a valid and scientific alternative, that evolution has gaps and flaws in it, that it is essentially problematic, that if students were interested in learning more about intelligent design, which would not be taught, and they thought that would help them to say that they were directed to a book in the library called The Pandas and People, that in fact was the basic text for intelligent design. So the statement over the course of several minutes, as it was read, not only juxtaposed intelligent design and evolution, but also at the same time denigrated evolution. Hard to boil the case down to an executive summary, but in essence, using the legal precedents that I just mentioned, the cases that came before, I was tasked to apply those to the facts and make a determination as to whether or not this enactment by the Dover Board violated the Establishment Clause. And it's interesting, I should tell you as part of the backstory, that the teachers themselves refused to read the statement. They mutinied. And the school administrators, the superintendent and the assistant superintendent, had to read the statement because of that. They had to walk the plank because the teachers would not read it, and so they tried to say later in the trial that this was not teaching. And they also had an opt-out statement out of an abundance of caution, which made a bigger hash out of this than it already was. So imagine this was supposed to, their defense in part was, look, no harm, no foul. Students, much ado about nothing. Well, so a student the day before the statement is to be read had to take an opt-out form home and advise their parents about something that was completely inscrutable. Johnny or Susie is about to have a several-minute statement read to them tomorrow. You can opt out. You don't have to have Johnny and Susie in the room. The parents had to figure out what they wanted to do, either keep the student in the room or have the student out of the room. And then the next day, if Johnny or Susie stayed in the room, you had either the superintendent or the assistant superintendent come in the room. And you know, those of you who teach know what the frequency is that the superintendent or the assistant superintendent comes into the classroom, and when it happens, it's a notable thing for the students. And then with all the attraction and allure of somebody making a hostage tape, the superintendent would read the statement and then say to the students, good luck, we can't teach this, and then they would leave the room. But that wasn't supposed to be impressive to students or make an impression, indeed, on students, which I found interesting during the trial. The board at Dover, the school board, and one of the school board members who was a thought leader on the board. You saw in that vignette, his name is Bill Buckingham, the fellow who said it was like we shot their dog. And they were young Earth creationists, and they were determined that they wanted to rip evolution out of the curriculum, and in fact try to get something in that smacked of creationism, and they found exactly what they thought they needed in intelligent design. They couldn't explain during the trial what intelligent design was. But what they thought they knew was that intelligent design was exactly what I said that it was, that I said it was at the end of the trial, which is the successor, the progeny of creationism, creation science, creationism, creation science, intelligent design. There's not much separation in those concepts at the end of the day, in my considered view, having heard the testimony. Many said after the case was decided, what is this arrogant federal judge in Pennsylvania doing, deciding what is good science in the United States? And in fact, little known is that federal judges decide scientific questions every day. And we do that not because we're so smart, but we do that because we have tools that allow us to make scientific determinations. And it happens that these come up in trials. For example, you may have a trial over a pharmaceutical drug where somebody is alleging that it caused harm, and you have experts testifying on both sides of the issue, and we've got to make a determination as to whether or not an expert's opinion is grounded in good science. How do we do that? Well, we look at, for example, if there is a scientific theory or an expert report that cites to a particular methodology. Is it testable or falsifiable? Is it generally accepted in the scientific community? Has it been peer reviewed? All of those things, they're not exclusive, but they're major touchstones that we use. And so I did in this case. And at the end of the day, as you know, if you know anything about the case, and as implied by the DVD, I found that intelligent design was not science. And that it was, as I said, the successor in the line of concepts starting with creationism. I know that my decision has not ended the controversy by any means, by any stretch. And in various places across the United States today, there are festering disputes. I know that it has been an issue, of course, in this state as well. It's not my job or my task to wade into those debates. You can read my decision and you can understand, I hope, what I saw and what I believe the case to be based on the facts as they were put before me and the law. I think that as we go forward, you're going to see federal jurisprudence evolve, to use the word, as well. And we don't know where that's going to go. There are two schools of thought, two main schools of thought, as they attend, not necessarily just evolution, although that's something of interest to you, but I'm talking about the larger question of how strong is that wall of separation between church and state. Many believe, led in the Supreme Court of the United States by Justice Scalia, for example, that is not an appropriate reading of the Establishment Clause. That's attaching something that Thomas Jefferson said and bolting it into the Constitution impermissibly. And so he does not believe that the test that we use and the analysis that we perform is appropriate in these cases. There is another school of thought, of course, that believes that there is indeed a wall of separation between church and state, and that is good law today. I should tell you that unless and until the Supreme Court of the United States loosens or changes the tests that we utilize, then you'll continue to see cases that will look with a very clinical eye on enactments in the public schools that purport to perhaps bring religion into the classroom. And the enduring lessons for me stemming from this case are several, and I want to mention them, and I would be remiss if I didn't mention them. One is that a substantial number of our fellow Americans do not understand the science of evolution. That's not a surprise to you. And unfortunately, of that larger grouping, there's a substantial subset that choose not to be troubled by facts, scientific facts. And and generations of study. And secondly, we are bereft increasingly, I think, in the United States, of a good bedrock civics education. That is not an original thought of mine. That's something that, for example, a person who's become a friend of mine, former Supreme Court Justice Sandra Day O'Connor, who is a magnificent person, by the way, has made it her work now since she's taken herself off the court a couple of years ago, to get around the country and talk about how we need a better civics education, because frankly, people do not understand how judges work. In the context of my case, people said, well, we have a fellow who was a Republican. He was appointed by George W. Bush to the federal court. He must be with the program, and certainly he's not going to rule against the Dover School Board, and certainly he's going to allow intelligent design in. That neglects to understand that that's not the way our judicial system works. I would like to think that any federal judge in the United States, faced with the facts in this case and the law as the law exists today and as it existed then, as I tried the case, would have made the same decision that I did. They may have written it in a different way. The scope of the decision may have been different, of course, but they would have come to the same essential holding, which was that the Dover policy was unconstitutional. And that's because of a principle known as stare decisis. That is, we build on the law, and we have precedents that we follow, roadmaps that we follow. We don't lick our fingers and put them up in the air. We don't rule according to personal philosophies. We don't rule in a way to please our benefactors, those who appointed us to these wonderful positions that we hold. We do our jobs, and that's what I did in the Kitzmiller case. But unfortunately, most of our fellow citizens simply do not understand that, and they assume that judges rule with abject bias. And sort of concomitantly, there is another thing that we neglect to understand about our branches of government. First of all, if you pull a lot of Americans off the street and test them, many of them, I'm sad to say, and you probably know this, can't name our three branches of government. But as it attends the examination of the three branches of government, one of the things that is really lost in the educational process is what our framers, who labored so many years ago in Philadelphia, intended. Article 1 and Article 2 respectively set up the Congress and the presidency, the executive branch, legislative branch, executive branch. Our framers intended both of those branches to be majoritarian. It's the way the Constitution was written. That is, the branches reflect the will of the people. And that makes logical sense. The members of those branches stand for election. So at any given time, they need to be responsive to what the public wants. But the framers did something that I think showed their foresight and their essential genius in designing all three branches, but particularly with respect to my branch, which is the third branch of government. They made the third branch counter-majoritarian. Now, what do I mean by that? Well, we're not elected. We're appointed. Now, some people have a problem with that. They don't think that that's right. They think that we should be more accountable. I would suggest, though, that we are, through the appointment process, which is something that has checks and balances. The president appoints, the Congress has to confirm us, so there is a check, a natural check and balance. We have an appellate system where we go through different tiers of courts, through the trial and the intermediate appellate and the Supreme Court. But the courts at bottom, Article 3, set up a system of courts that was designed to be a bulwark against the tyranny of the majority. We are not majoritarian. We're not responsive, and we understand this directly to the people. That sounds odd, but our first responsibility is to the law of the United States, both the statutory law and the law that has been made through cases, and of course the Constitution and the Bill of Rights. And when you think about it in the context of the Dover case, you look at it this way. If you poll in the United States today, you'll find that of our fellow citizens, about half believe either that creationism should be taught, or they disbelieve evolution all or in part, And there's a great split, almost an even divide in the country. And sometimes I think that's even a higher number. I'm not sure that that polls properly. So people wondered. We didn't really understand the way that the three branches operate. Look, school board voted for it. They enacted the policy. After all, maybe it could be that a majority of Americans are for a policy of this type. Why doesn't this judge just get with the program? Why doesn't this judge just do what he ought to do and find the policy to be constitutional? Again, there is this troublesome thing to some known as the Establishment Clause within the First Amendment of the Constitution. And we are tasked in our time as judges to make decisions that are going to be unpopular, and we know that with a significant number of our fellow citizens. And so I applied the law in a way that I knew, of course, would be controversial. And indeed, the majority, the tyranny of the majority in this case, was a faction of a school board, really a bullying faction, that tried to have their way and to overwrite the provisions of the United States Congress, or United States Constitution, which is simply not permissible. As I go around and speak, I am so heartened by the interest that people have shown in my case. But I've also had the opportunity and the good fortune to meet people from across the world, not just from the United States. And you need to understand that for people in Russia, for people in emerging nations across the world, our judicial system in the United States is the envy of the world, the envy of the world. Because in so many countries, Russia being one even today, if people in other branches of government disagree with something that a judge does, that judge can be taken out of office. That judge's liberty may be at stake. It may be that the pronouncement of the judge or judges is simply overlooked and disregarded. That's not the case in the United States. And I hear time and again from my friends in other countries how they appreciate so much what we do, and they wish that they could have a judicial system, and in fact have tried in these emerging nations to model their judicial system after our Article 3 creation in the United States. And it's well to reflect on that, because we tend to be appropriately cynical in the United States, and we appropriately question the institutions of government, as we should, and I would never argue against that, but we sometimes should stop and reflect on the good things that we have in the United States. Judges are fully capable of getting it wrong. Believe me, I've made some bad calls. Just like an umpire who misses one that lands on the other side of the foul pole and calls it a home run, or makes that blown call at first base. And I'll make more bad calls before I hang up my robe and leave the bench. But the fact of the matter is, you should be comforted by the fact that day in and day out, our federal judiciary in the United States is hard at work. And we do take this seriously, and we do the very best job that we can. Again, it is my honor and pleasure to be with you. I thank you so much for coming out this afternoon to hear me speak. I understand some of you will be leaving, and then we're going to take some questions as well. Thanks so much.
Some of you have to leave. Why don't you leave now, those of you that have to? You have classes and other kinds of things. Those of you who are interested and have the time, we're going to stay and engage Judge Jones in some questions. So those of you who have to leave, this is a good time. And let's get you out of the light.
Yeah. All right.
Got it. Okay. Anyway.
Questions? see everybody, but anybody have questions? Okay, where else? Who am I?
Stand up and holler.
Yes.
Somebody stand up.
Okay, I've got one.
A question regarding terminology and what is science and what is not science. Pet peeve of mine is how we continually refer to Darwin's theory of evolution.
Yes.
And what makes science science is that science evolved with more data and so on. To call it Darwin's theory of evolution, to me, denigrates modern evolutionary science.
Yes.
And relegates it to something 150 years old.
I understand. Yeah.
What do you think that terminology impacts the argument?
Well, I come to you as, I always joke that federal judges are the last of the great generalists. So I'm not an expert in that area, and I don't mean to be, but I've heard that before. And sometimes I say Darwin's theory, and I catch myself because I think of my friends in the scientific community who cautioned me, and they said, you're not giving the appropriate picture or terminology when you say. Well, and I'll answer it this way. What I find interesting in this whole debate is the ISD, Darwinist, and that's so. I think that's to your point, that's a lot more pejorative. Anything that ends with IST typically is trouble, and so you walk into that. The other way I'll answer it is. I took high school biology. I was a political science major. I took geology when I was at the good old Dickinson College back in Pennsylvania in my time there. And I'm not a biologist by any stretch of the imagination. Of course, if you talk to the intelligent design folks, I think I don't understand science anyway. So, but I was struck by. I don't want to write Darwin out of the picture because I was struck by how much he got right. I'm sure you are too. There's two sides to it, I guess. With so little at his disposal, other than his observational powers and the stick-to-itness that he had and his his intellect, he truly was genius. It was a genius, so I've grown fond of that story. Even though from the mapping of the genome to everything that's happened since, right in the middle of the trial, which I found ironic and sort of funny. And I forget now, and excuse me because some of this leaves me, but a fossil was discovered that bridged one of these supposed gaps. In the record, which sent some of the defense witnesses, I think, screaming out into the hallway. But all these things tend to complete the picture that Darwin framed out. But I agree, you do get into excessive dogma when you invoke Darwin's name, again and again. But I'm afraid I'm tethered to old Charles, history. By no means do I equate myself with the great thinkers of the age. And my one joke about the decision, I said, I don't know how my decision is going to hold up over time, but I know that I've written the first line of my obituary. When I croak, that'll be the first thing that they say in the first line. Yes, sir.
So you mentioned that Darwin was afraid to publish his book. Were you afraid to reach your conclusion, and did any of those fears come true?
No. No, I wasn't. The question was, I mentioned Darwin's fear about publishing, and did I have a similar apprehension? No. I did what I had to do. I knew that it would be controversial. However, I will tell you, and it's been written about, this is not news, I immediately received death threats, and I had U.S. Marshal protection around the clock for a week, more than a week after the trial, and that was distressing, to say the least. And I've never had a similar experience in a civil case. Our Marshal Service is like our Secret Service protection. We don't have them all the time, but they're there if we're threatened. And I immediately had anonymous and sufficient enough threats that they gave me a detail. And it's not just unnerving for you, but I had my two children who since grown, obviously. One is in college and one is out of college, but they were home at that time, and my wife couldn't walk the dog without a marshal walking next to her. And that's one of the sadder statements about the case. I didn't anticipate that, obviously, but no, I wasn't afraid. In fact, it was I got the case decided. I told the lawyers that I would get it finished by the beginning of January. I thought the first couple of weeks, but I always intended to get it done if I could by the end of the year. And this was just a personal thing. I didn't want to go into the Christmas holidays with this case on my docket. And I told my clerks, I said, we're going to get this finished before Christmas so we can all have a happy holiday, because I could barely stand it. Every time I would look at it, it was 139 pages, I'd find something I wanted to change, and I said, we have to get our heads out of this, or we're going to drive ourselves crazy. Yes, sir.
Two-part question. The first part is, I'm curious on what grounds you think that the Establishment Clause is vulnerable to reinterpretation by the Supreme Court. So what would be the basis for doing that? And then the second part, if it was reinterpreted, what sorts of laws would be considered constitutional that currently or recently have been considered unconstitutional?
Yeah, well, the second's harder than the first. The movement has been deemed the accommodationist movement, and that is principally led by Scalia, I think, and others who say that we're entirely too doctrinaire, and we're dropping the knife in a way that the framers never intended it to be dropped. There are other members of the Supreme Court, Thomas would be one, who believed that the Establishment Clause should never have been applied to the states, that it uniquely meant, it says Congress, it means Congress, it never should have been applied. We'll never roll back to that. I mean, that ship has sailed, so to speak. But I think what they'll say is that some enactments, so long as they have, for example, mixed purposes, and I don't want to get into giving examples, because these cases, cases like this could come before me, and we shouldn't do that. We shouldn't give hypotheticals. But some enactments that have mixed purposes, some of which have to do with teaching or expanding knowledge, even though they may have a religious aspect to them, should be able to get into the through the front door of the public schools. What they're looking for, I think, the folks who want to see, there are two tests that we use without getting excessively legal. One is the Lemon test, the other is the endorsement test, and they task us to measure the purpose of the enactment and the effect, and whether it excessively entangles religion in the curriculum. Using Dover, using a past case as an example, the school board, when it passed the policy, said essentially, this policy is to encourage critical thinking amongst students, period. That was the purpose of the policy. And if you take the accommodationist viewpoint to an extreme, what they're basically saying is, I'm stuck with that. I can't go back and look at the history of the enactment of the policy, which you can do now. And I could look at all the school board meetings where, people got up and accused other school board members of being atheists, and they talked about creationism, and all these things were part of the soup that was created. So, it's limiting the inquiry and, for example, saying to a judge, you're stuck with what the pronounced justification and rationale is for the policy. So it's sort of stay tuned. This is a very split court, the Supreme Court. It's interesting for those of you who watch these things. The court is 4-4 with a swing vote, and that's Justice Kennedy. Justice Kennedy, I think, is the most powerful man by any legal analyst's judgment on the Supreme Court. As Kennedy goes, typically now, so goes the court. You're going to see a lot of 5-4 decisions. There's no case that I know of now that is a good case to disrupt Establishment Clause jurisprudence, potentially. It may or may not, but watch for that in the next couple of years. I think they'll be a fight someplace. Other questions? Yes?
What do you think of the Supreme Court decision a month ago versus the campaign finance? Is that a revision?
Well, you know, again, the question was, for those of you who didn't hear, what do I think of the decision reversing or speaking to the issue of campaign? It really wasn't campaign finance anyways. It's a free speech case, as it had to do with corporations properly characterized. I'm not in the business of commenting, and I shouldn't be commenting publicly on particular Supreme Court cases. But to say this, and I don't mean to dodge your question, but it's just not an appropriate thing for a federal judge to. We try to stay away from that type of an analysis. Whereas I've also joked that technically, in the pecking order, you know, John Roberts, who's the Chief Justice, is my boss because he's the head of the federal judiciary. And if I don't watch what I say, I could lose furniture, I could have my chambers, all kinds of terrible things happen. But that case, I think, stands for the proposition I just spoke to, which is that was a tremendously split court. And I will just simply say that it is troublesome to us who toil in the lower courts when the Supreme Court can't get a good consensus going, because it is a brutal opinion to try to read, because there are dissents and concurring opinions, and it's very long, and it's kind of a mishmash type of opinion. So I would want generally opinions that apply more clarity than that. It's clearly a court that's having trouble finding its voice. You know, the best chief justices, and John Roberts may turn out that he can forge these consensuses, because Rehnquist had a hard time with it, and then eventually came around and was able to bring his court with it. The best chiefs, Republican or Democrat in their origins, you know, you shed your politics when you go to the court. You may not shed your philosophy, but you shed your politics. The best chiefs are the ones that can get the justices to sort of speak together. If you go back and you look at Brown versus Board of Education in the 1950s, that was a 9-0 decision. U.S. versus Nixon, the case that compelled Richard Nixon to turn over the tapes in the Great Watergate scandal, that was a 9-0 decision. You know, so cases that are close calls are tougher for judges and litigants and lawyers to apply. Yes?
You commented, I hope you're right about this, that most judges would have come to the same decision you did in this particular case. But I'm curious how you would reconcile your comments about the split nature of the Supreme Court with this idea that personal bias, political bias doesn't enter into the decision.
That's a really good question. And remember, they're at the top of the food chain. And it's an excellent question. I'm taking the law as it's handed to me. You know, I don't. You know, I occasionally get cases of first impression where we don't have any established law, and I've got to make the best call that I can, and I essentially create new law, and typically that gets tested up through the appellate courts. But generally, most days, most cases, I'm applying law that has been handed to me by the Supreme Court or by the intermediate appellate courts. And so when I make that comment, I'm simply saying that on the facts of this case, applying the law, which I have to apply whether I agree with it or disagree with it, they would have found the same. But at the top level in the Supreme Court, philosophies do come into play, and I don't mean to write that out of the equation. When I talk about judges making calls, you know, not with respect to any particular philosophy, I'm talking about trial judges in the intermediate appellate court. So you ask a very good question. Philosophy does matter, obviously. If you're Antonin Scalia and you're what is known as a strict constructionist, you know, you take the tack that if it's not in the Constitution, then you don't write it into the Constitution. You don't imply something that's not there, and then you take the other side of the equation. You take a Steve Breyer in the Supreme Court who says the Constitution is a living document. Scalia counters that the Constitution is dead, and it is what it is. It's there, and it's not breathing, it's not organic, and you don't write anything into it. So you do get different decisions when you look at those two philosophies colliding. But even on the Supreme Court, and I should say this, that what you find out, one of the great things that happens when you're in your first year as a federal judge is they take us down to Washington, and they do this annually with a new class of federal judges, and they have us to this very intimate dinner with our spouses at the Supreme Court, a candlelight dinner where the justices come and they sit with us. And they're good people. They really are. And they get along really well. They don't fight. They respect each other's opinions. They really try, very hard. They're having, as I said, some trouble finding their voice, but they work at it. And Ruth Bader Ginsburg, this has been written about for those of you who are interested in things like this. Ruth Bader Ginsburg was, admittedly, by most accounts, a pretty liberal member of the court, and Scalia, who admittedly is a very conservative member of the court, love to go to the opera together, and they hang out together, and they eat dinner together. And if you had 10 issues, they'd agree on about 9, or they disagree on about 9 of them, maybe 9.5. And they throw zingers at each other in their opinions, but they have a marvelous relationship, and they get along. And on my court, I have a number of judges on my court who come from different philosophies and political backgrounds, but we all get along, and I think that's the nature of the third branch, and it makes your work life a lot easier when you deal well with your colleagues. Other questions? All the way to the back. Yes.
I can't help noticing the parallel between working in the judiciary and being a member of an academic faculty, in as much as you have to make judgments based on facts and not by opinions, sometimes even your own opinion. I was wondering if you could comment on that, and then also tell us if you have any experiences with academic judgments, judgments related to academic issues that you've had.
I can't compare the two because I've never been on I've never been in the faculty, so I'm not sure. But if there, I'm sure there probably are parallels in terms of collegiality, without question. The biggest school case that I've ever had is a case that arose out of Shippensburg University in Pennsylvania, and that's from back in 2006 or so, and it was a case, and this doesn't directly involve the faculty, but it reminded me of it when you talked about colleges and universities. It was a speech code at Shippensburg that was called into question, and it was a code, there were many like it in the United States at that time. I think they've been reformulated and modified, and it essentially I found it to be a violation of the First Amendment in that it was too restrictive. It attempted to tamp down speech that was controversial in fact, and so it was changed. And I think some other cases followed that, and they were sort of utopian type speech codes that. Why can't we all get along, and why can't we all say nice things? It was a case was started by some students who had pictures of Osama bin Laden that they put in their door with the circle and the strike through it. And this was in the immediate aftermath of 9/11, and the university made them take them down. They said, you shouldn't do that. You don't want to have that sends a bad message. We don't want pictures of Osama bin Laden with a slash through his face, and they ended up going to court. So, a very interesting case at the time. Yes?
We have time for last question.
In your case, was it ever like a turning point, or was it hard to begin?
Was there? I'm sorry, say again. Was it?
In your case, like legality-wise, was it hard all the way up to the end, or was there a certain turning point where the evidence was back that the ID people, with the copy and pasting and all the evidence and the biologists coming?
I get asked that question a lot, and essentially, the way I answer is this: at the end of the plaintiff's case, after I heard from the plaintiff's experts who were marvelous, starting with Ken Miller, who you saw, and I know has been here, and the orchestrated by Jeannie Scott, who has been here as well. She was coordinating the science witnesses. It was, if you use the analogy of a football game, the defendants were behind about 40-0 at the end of the plaintiff's case. So there was a way to come back, but it would have been miraculous. They were in a very, very deep hole. But I took it all, you know, as it came, and I didn't have a predisposition. I really didn't. The other question that, you know, was asked me is, did you study up before the case? And I didn't, because that's not appropriate for us to do. You know, I had to rule on the evidence as I heard it in the courtroom, and I'll close with this. I mean, it's not necessarily apropos of your question, but to show you how little I knew about the topic, the one topic that I was going to get. I heard about the case as I was driving home from court one day, and it was at the day that the lawsuit was filed. And there was a huge press conference hallmarking the filing of the case. That was in the state capitol in Harrisburg, Pennsylvania, in the rotunda. The parents and their lawyers talking about the fact that they filed this big bombastic lawsuit about the Dover policy. And they said that they filed it in the United States District Court for the Middle District of Pennsylvania. And as I was tooling up the interstate, listening to this on the local radio station, I distinctly remember this because I had two thoughts at that time. And the one thought was that although I like to think of myself as relatively well read, I could not remember ever having heard of intelligent design. I didn't know what intelligent design was, to show you I didn't have any predisposition about intelligent design. And of course, the second thought that I had as I was heading up the highway and going home was, I wonder who's going to get that case. Thank you all.
Thank you all for coming. It was a wonderful afternoon.